OMG. Have you heard about this? That is the opening line of an advertisement. It ran on Instagram to a verified account with millions of followers, and it read like a friend telling you something. So I talked to my doctor. He prescribed me #Diclegis, and I felt a lot better, and most importantly, it's been studied and there was no increased risk to the baby. Then the Food and Drug Administration wrote to the drug company behind it and said that post was false or misleading. August 2015, a health regulator. October 2022, a financial one. 6 years apart, two regulators, two different industries, and the same finding. A paid post that left out the thing that mattered. And here's the part that makes this an episode instead of a headline. Both times, the post said it was sponsored. Kim Kardashian sells work, not products, although there are products and they are enormously successful. She sells the idea that the reason she has what she has is that she got up and did the work, and that you could too. I have the best advice for women in business. Get your fucking ass up and work. It seems like nobody wants to work these days. She said that promoting a television show about her family. It went around the world. And it is worth being precise about who she was talking about, because almost nobody has been. Sentence 1, advice for women in business. Sentence 2, nobody. The first sentence names an audience. She chose it herself. The words advice for women in business are hers in the quotation, not a question put to her. The second sentence has no subject at all. Not women, not her staff, not anyone. Just nobody. And it landed in 2022 into a year of headlines claiming nobody wanted to work anymore. So who did she mean? She never says. And that is the whole reason it went the way it did. A sentence with no subject, so everybody filled one in. Afterwards, she said it had been taken out of context, that it was never a blanket statement about women. Variety published a rebuttal disputing that. She says, taken out of context. Variety says, it wasn't. We are not going to settle that for you. Both are on the record and both stay there. What we will say is what the page itself shows. In the printed piece, there is no question in front of that quote. It sits on its own. That is consistent with her account that the conversation around it was cut. It is also true that the framing she is judged on is inside her own sentence. And the same interview carries the other half of her, which is not a throwaway. We work our asses off. If that's what you think, then sorry. We don't have to sing or dance or act. We get to live our lives. And hey, we made it. This film is not about whether she works hard. By every visible measure, she works extremely hard, and we will get to what she has built. It is about the two occasions when the work she was paid for was a post, and a regulator looked at it afterwards. 7 August 2015, U.S. Food and Drug Administration Office of Prescription Drug Promotion. In 2015, she posted about a prescription morning sickness drug called Diclegis. The drug company submitted that post to the FDA as its own promotional material, and she named the partnership in the post itself. I'm so excited and happy with my results that I'm partnering with Duchesne USA to raise awareness about treating morning sickness. That is a disclosure. It is right there. The FDA's Office of Prescription Drug Promotion looked at the post anyway and found this. The social media post is false or misleading in that it presents efficacy claims for Diclegis, but fails to communicate any risk information associated with its use, and it omits material facts. Not that she was hiding the sponsorship, that the advertisement was all upside. No risk information at all, no mention of the drug's own stated limit. The post carried a link at the end. Find out more. Safety information. The FDA addressed that directly and said it does not mitigate the misleading omission of risk information. And the second omission is the one we're sitting on. The drug's own approved labeling carries a limitation of use. It had not been studied in women with hyperemesis gravidarum, the severe form of the condition. The post did not mention it. The regulator's own summary of why this mattered. These violations are concerning from a public health perspective because they suggest that Diclegis is safer than has been demonstrated. The letter went to the drug company, not to her. And this next line is not optional. The warning letter was addressed to an executive vice president at Duchesne, the manufacturer. She was the paid spokesperson. The regulated party was the company. The FDA did not fine her, did not sanction her, and did not write to her at all. The post came down. 13 June 2021, one Instagram story. 6 years later, she posted about a cryptocurrency token called EthereumMax. She marked it #ad. On the 3rd of October 2022, the Securities and Exchange Commission issued a settled order. And the numbers are worth taking from the order itself, because the SEC's own press release blurs the first two together. Disgorgement, $250,000, the amount she was paid. Interest, $10,415.35. Penalty, $1 million. Total, $1,260,415.35. The finding was under Section 17B, the anti-touting provision, which makes it unlawful to promote a security without fully disclosing the receipt and amount of what you were paid. She marked it as an ad. She did not say what the ad was worth. One post, $250,000 to 225 million followers. That follower figure is the SEC's, and it sits inside the finding. She settled without admitting or denying the findings. She admitted only that the commission had jurisdiction. That is how the great majority of SEC matters end, and it is not an omission of anything. She also gave an undertaking. For 3 years, no compensation of any kind for promoting a crypto asset security. 6 September 2021, Charles Randall, Chair Financial Conduct Authority, United Kingdom. 9 months before the SEC order, the chair of Britain's financial regulator gave a speech about crypto tokens and used her by name. When she was recently paid to ask her 250 million Instagram followers to speculate on crypto tokens, it may have been the financial promotion with the single biggest audience reach in history. Now, you will find it reported that he called her promotion fraudulent. He did not. What he actually said was this: of course, I can't say whether this particular token is a scam. His point was smaller than fraud and much more uncomfortable. In line with Instagram's rules, she disclosed this was an hashtag ad, but she didn't have to disclose that EthereumMax, not to be confused with Ethereum, was a speculative digital token created a month before by unknown developers. She followed the rule. The rule did not require the thing that mattered. That is the same shape as 2015. The disclosure was made. The disclosure was never the problem. In EthereumMax investor litigation, U.S. District Court, Central District of California number 2:22-CV-00163. In December 2022, a federal judge dismissed a class action brought by investors against her and other promoters. It was reported as the end of it. It was not the end of it. The dismissal was with leave to amend, which means the judge told the plaintiffs to try again. And when he dismissed it, the judge wrote a sentence the press cut in half. The half everyone ran said investors should act reasonably before basing their bets on the zeitgeist of the moment. Here is the half they didn't run. This action raises legitimate concerns over celebrities' ability to readily persuade millions of undiscerning followers to buy snake oil with unprecedented ease and reach. Same sentence, nothing misquoted, just the harder half left out. December 2022, dismissed with leave to amend. October 2023, third amended complaint, 168 pages. November 2023, she answers it and demands a jury. August 2025, 4 state classes certified. On the 6th of August 2025, the court certified 4 classes: California, New York, Florida, and New Jersey. It refused a nationwide class. She is a defendant in a certified class action. Now, carefully, because this is where it would be easy to cheat. Certifying a class decides how a class is tried. It decides nothing about whether anyone did anything. The judge said so himself and went further. He wrote that the harder questions are for a later stage, and that he would consider undoing the certification if the circumstances warranted it. Nothing has been decided. She denies all of it. And one thing that is almost never said out loud: she is not accused of insider trading. The complaint has 14 counts. That one names other defendants. It does not name her. The case was filed in January 2022. The trial date has now been moved 4 times. As of the day we finish this film, it sits in July of 2027, 5.5 years after the case was filed, and a year and a half later than the date the court first set. 27 January 2026 to 28 July 2026 to 23 February 2027 to 20 July 2027. The most recent move came on the 4th of August, days before this film was finished, on a stipulation the parties filed jointly, Kardashian among them. What the record also shows: she has never been charged with an offense. There is no criminal case here, and there never has been. The 3-year undertaking she gave the SEC lapsed in October 2025. Nothing on the public record shows she has promoted a crypto asset since, and that is worded exactly that way on purpose. We looked twice and found her business in detail and no crypto promotion in it. An absence of evidence is not a finding, and we are not going to dress it up as one. In the same period, she built a company. Skims was valued at $5 billion in a funding round led by Goldman Sachs Alternatives. The SEC order is settled and paid. The lawsuit is undecided. The difference matters. And the plaintiffs suing her concede a point in their own complaint that the SEC's findings are not binding outside the SEC's proceeding. Her own argument filed with the court is a serious one, that there is no evidence buyers were uniformly exposed to anything she said, and that no plaintiff bought a token from her. The court set that aside for the purposes of certification and told her twice she could raise it again. Two regulators, 6 years apart, a health agency and a financial one. In 2015, she wrote that she was partnering with the drug company. In 2021, she wrote #ad. Both times the sponsorship was right there in the post. And both times, what a regulator found missing was everything that would have made the thing she was selling look like less of a sure bet. The risks, the limit on what the drug had been tested for, what the token actually was, and who had made it a month earlier. The disclosure was never the problem. She sells work. The two pieces of work in this film took a few minutes each, and one of them paid $250,000. No verdicts, just the record. We showed our work. Go check it.